seeking immediate investigation against the Arup বিশ্বাস, the then Sports Minister, and the member of the Legislative Assembly and his men agents for commission of offences of extortion, criminal intimidation, abuse of official and political influence, illegal diversion, monetization, sale of complimentary tickets issued for the said event for wrongful gain. During the organization of the events, the Arup বিশ্বাস, the then so-and-so, repeatedly demanded substantial number of complimentary tickets, accreditation cards, and close proximity passes, and continuously threatened and pressurized by stating indirectly and indirectly that without his intervention, the event would not be permitted to take place smoothly and would face serious obstacles. Acting under such coercion, intimidation, and fear of disruption of the event, I was compelled to hand over approximately similar the astronomical numbers. 22,000 complimentary tickets, accreditation cards, and close proximity passes to him. These tickets were not voluntarily given but were obtained through persistent pressure, threats amounting to extortion and criminal intimidation. Thereafter, Sri বিশ্বাস, the then so-and-so, demanded an additional 8,000 complimentary tickets, which I refused, as no further tickets could be issued. Subsequently, through members of Messi fan club, attendees, members...
What are the sections fastened?
Yes. Now, the sections are 3 subsection 5. 3 subsection
3082, 3018, 18.4.
Yes. So common intention.
These are cognizable and non-bailable offences.
Most are cognizable, one is non-cognizable.
308 and 318.4.
These are cognizable.
Cognizable, non-bailable.
Yes. Non-bailable. Now, Milord, these are all, Milord, within 7 years.
But up to 7 years.
Yes, up to 7 years. Now, Milord, first is, Milord, extortion and cheating, Milord, cannot go together. Either I extort a person or I cheat a person. Now, Milord, first is, Milord, under, Milord, 173, subsection 3, read with, Milord, the principles, Milord, laid down, Milord, by Lalita Kumari's case, Milord. Milord, because of this delay, Milord, there was a requirement of preliminary inquiry. Milord, in our submission, Milord, no such preliminary inquiry was done. Number 1. Number 2 is...
But why you are not complying with 35.3 notice?
Yes, we will. But, Milord, the way, Milord, the police is acting...
When you will?
I'm sorry?
When you will comply?
Milord, your Lordship, Milord, gives us protection. We'll go tomorrow, day after tomorrow, whenever they ask me. But Milord, the persecution which is taking place, Milord, your Lordship should take judicial notice of that.
Mr. Dotto, come to page 78.
70.
78.
78.
78. Achha,
Yes.
Yes.
It's a newspaper clipping.
Yes. Yes.
Is he your client? Standing beside Messi?
Yes, he's my client. He's my client. But this cannot be an offense. Now, what the...
Does it not breach the security of this soccer legend?
No, then kindly look into, Milord, the FIR.
How he can do this?
Mr.
Mr. Dotto, how he can do this? Is he Messi's childhood friend?
No. Look in. Milord, I was given a proximity card, Milord, which we have annexed at page 40. Please take page 40.
Spreading his hand around the waist of Messi?
Yes. Kindly have a look to page 40. He was given a card, Milord. There were other people also.
How he did this?
Milord,
On
first...
print media, on news media, all we are the residents of Kolkata felt ashamed because of this Messi incident fiasco.
Milord, it shouldn't have happened, Milord. I won't say that, Milord, we were glorified by that incident. Never. But the point is, Milord, number 1, Milord, he was given a proximity card. Why? He's the sports minister.
Proximity
or rather
means to such a proximity.
But few proximity cards were issued. He was one of
and when
the
such
persons...
incident was smoothly organized in 3 other cities metro cities of our country.
Absolutely.
My lord, I cannot join issue on that. My lord, I
And
cannot.
he was none other than sports minister at the relevant point of
My
time.
lord, the organize. My lord, I will not, my lord, point fingers at others.
Will come later on.
Yes.
But what about the incident?
Where the incident has happened, well, please consider whether there is any criminality on the part of the petitioner in the happening.
I will direct the concerned police authority to file an independent report before this court about this fiasco.
Yes, yes. I
Because
think
everybody saw on print media, on news media, that there were large number of intruders at the field on the said date, for which Messi had to leave the venue
right, right,
due to security breach.
right. Now, my lord, your lordship may kindly look into, my lord, what was contemporaneous.
Then I will consider your prayer for quashing that how far it is maintainable.
Yes. No, my lord, the prayer for quashing, my lord, may I very humbly submit, my lord. My lord, the prayer for quashing, my lord, has to be dealt with, my lord, on the parameters which your lordships have laid down. We got some breach over there somewhere. We got some over enthusiasm. Some
Total
over.
mess.
Yes, yes. Well, I say
And
so.
the petitioner was none other than the sports minister at the material point of time.
Millard, your lordship kindly recollects that we have said so here also that we have, my client had resigned contemporaneously. He was not holding on to his post.
How do you justify this picture at page 70?
Millard, I will not justify. But please consider, Millard, whether, Millard, this gives the right of the state police to persecute me. Does it give? That is, Millard, not Millard, what is enshrined in our constitution. Millard, I have come up before your lordship because of the threat to my personal liberty. Now, I have to justify that, definitely. I will have to justify why I feel.
The Mitro,
Yes.
all leading sections are 3082 and 30184. All are below 7, up to 7 years.
Yes.
Yes,
Yes.
cognizable, non-bailable. But since it is up to 7 years, so therefore petitioner is can get the protection under section 35(3). 35(3) protection petitioner can get, but I am not aborting this investigation process. Investigation process will will be carried out. Petitioner will comply with 35(3) notice, and but no coercive steps in the meantime.
Two
Let the
submissions.
report comes, and in the meantime,
Two
due to
submissions.
such incident which shook the conscience of all the persons who are dwelling in Kolkata, I will direct the concerned police officer to conduct an independent inquiry and submit a report before this court. That which I am also thinking about.
Very well, my lord. So I have no difficulty so far as the other parts are concerned. My lord, two submissions. My lord, kindly once come to, my lord, paragraph 26, page 14.
But that has been withdrawn, my lord.
No.
Paragraph 26, page 14.
Yes.
I brought that judgment that even if it is rejected, I can file proportion. I think I brought that judgment.
Yeah.
We brought. No explanation as to why, my lord, it was required to be withdrawn.
Because we have filed the rectification.
No. I can overhear. No.
Please don't over here.
Now, there is no
Tell me that considering the
two
case-
further submissions. Lordship has seen this. He has to give explanation, no explanation given. Next, my lord, kindly come to, my lord, page 74. The notice, 35(3).
page 75.
Page 75, yes.
Yes.
Sorry. Page 75. Kindly forget about this. Kindly come to his reply, page 76. Fourth of June. Kindly bear with me, my lord, for 2 weeks. 4th of June. 4th of June. Now, Kindly come to the second paragraph. However, owing to the prevailing extreme weather condition and excessive heat, I have developed severe stomach ailment accompanied by dehydration, etc., etc. My blood sugar level have significantly increased. As a result whereof, I am presently incapacitated from physically attending the police station and participating in the investigation proceeding. At present, inability to appear is bona fide, unavoidable, and beyond control. No supporting document. No
That's
supporting.
why court is saying
I-
that let him appear in
May-
terms
may-
of the
may-
direction of this
May I,
court.
my lord, may I? Now, this was on 4th of June. Now, my lord, kindly come to page 82, his document. He gives the power of attorney, he goes to Alipur court and gives the power of attorney on the next day. He could have said, my lord, that yes, I am better, I shall now go. He does not do that. What happens, my lord? Again, my lord, a notice is given. When, my lord, the local police station goes to serve, my lord, the notice on him, the door is locked. It is pasted, my lord, he does not turn up.
Very well. Yes, I get your point that there is no justification of not complying 35(3) notice so far the petitioner is concerned.
Yes.
But at the same time, court has to consider 35(3),
yes,
where there is a protection so far petitioner is concerned. If petitioner complies with the notice,
no, then thereafter,
because
my lord, after
since
35,
all the alleged offences,
my lord, after
all the
35(3),
alleged offences are under where the punishment is prescribed up to 7 years.
yes, that's true.
Up to 7 years.
Now-
Now, therefore, let the investigation be carried on. Carried on, permitting the petitioner to appear before the investigating authority, but not to take any coercive steps.
Kindly, my lord, kindly bear with me. Kindly come to 35(3). Then, my lord, kindly come to 4. 35(4).
That we have right for the court. Because despite 35(3), we apprehend that I will be arrested. So, for 60 reason and arrest.
Kindly come to 4. Where such a notice is issued to any person, it shall be the duty
Of that
of that person to comply with the terms of the notice. He does not do that.
So court will direct him to appear.
It's not required. It's not required. Kindly come to 35(6).
Where such person.
Where such person at any time fails to comply with the terms of the notice or is unwilling to identify himself, the police officer may, subject to such order as may have been passed by a competent court in this behalf, arrest him. So, well, provision is given.
No, but if it is secured by the dint of the order of this court for his
My lord, I will
appearance
tell
before
you,
the
lordship.
notice for the purpose of investigation, and there will be a further direction that the petitioner will assist the investigating agency to conduct inquiry. What is the charm in arresting him?
I'll tell you, lordship. What is the charm? My lord, your lordship has seen, my lord, the respondent number 5 was arrested. He made a bail application. Now, my lord, kindly take, my lord, they have relied on. Kindly come to the, my lord, order which was passed in that. Kindly once pitched up.
No, I want to know from you that what is the what will be how it will be further facilitated in the manner of investigation.
Kindly
That
come,
is important.
kindly come to page 46.
Yes, I will not grant any protection to the petitioner, and he will be put behind the bars. How it will ameliorate the situation with regard to investigation process? Tell me,
Kindly
Advocate General.
kindly come to page 46 once. My lord. They have relied on this order. Kindly see, my lord, the stand which was taken, my lord. It's not, my lord, that a different stand is now being taken.
Yes.
Kindly come to page 46, second paragraph.
What is this order?
My lord, the
When-
bail application, the order passed in, my lord, the bail application of
Application of the petitioner.
respondent number 5.
Respond 5.
Shatudru.
Organizer.
Shatudru.
The de facto complainant.
Yes.
Yes.
Kindly come to the second paragraph of, my lord, page 46. Learned APP has raised vehement objection in regard to the bail application and contends that the investigation is in full swing, which also involves sessions triable offences, and if the accused is released at this stage, it will be detrimental to the investigation process and he may even evade the process of law as he is very influential. My lord, definitely, my lord, Shatodru is, or my lord, was less influential, my lord, than my lord, today the petitioner before your lordship. Besides, the accused person had disregarded agreement and the concerned government department, etc. Then kindly come to the penultimate paragraph. The crux and the premise of objecting the bail application by the prosecution and the investigative agency is that the accused, being an influential person, if released, will tamper the evidence, threaten the witnesses, will flee and will evade the process of law. Now, my lord, all this apply to him. All these apply to him, my lord. Now,
There is an allegation of distribution of tickets and passes to the tune of at the number is 22,000.
yes, yes.
This case.
Where is the denial, my lord? It's not required, I know. It's not required. But where is the denial, my lord, of the allegations made, my lord, in the FIR?
And the FIR allegations could not be
Now, your lordship has, I am not going into, my lord, the affidavit portion, my lord. In my respectful submission, the writ petition is liable to be thrown out at limine. Now, my lord, kindly see the allegations, my lord, those have not been, my lord, even, my lord, the affidavit does not cover those allegations. If your lordship is pleased to come to the, my lord, affidavit portion, it does not deal with. Somebody, my lord, a constituted attorney, my lord, files the power of, or files the affidavit stating everything as true to his knowledge. This cannot be looked into. Number one. Number two, my lord, he does not say that, my lord, what is his apprehension. Now, my lord, today, my lord, merely coming up before the court and saying that no step should be taken. Now, my lord, the ground has to be made out, which has not been made out. He is avoiding, my lord, the notice, my lord. There is no explanation as to why, my lord, this 35(3) notice was not, my lord, attended to by him in the affidavit, in the petition.
35(3) is quite specific. That it says, Mr. Mitro,
Yes, my
that
lord.
the police officer shall, in all cases where the
Yes.
arrest of a person is not required under subsection 1,
Yes.
issue a notice directing that person against whom a reasonable complaint has been made or credible information has been received or reasonable suspicion exists that he has committed a cognizable offense to appear before him or at such other place as may be specified in the notice.
Now, my lord, if he had complied with the notice, my lord, nothing would have happened.
Even then I could have arrested also.
So very well, I will direct him
No,
to
but let-
comply with the notice.
So
So therefore,
today-
he can get
to-
the protection under section
Today, my lord,
103.
in my respectful submission, it's entirely on your lordship, but my lord, in my respectful submission, 35(6), my lord, then becomes automatic.
Yes, to apply before the court under 35(6).
Very well.
You can apply before the court.
So no order is required. No order, my lord, no protection is required from this court. If I have to go before the court, I will go before the court. But in my submission, my lord, no protection. He will not comply with, my lord, the notice. The subsequent notice, he does not go there. He, my lord, notice is pasted in his house, my lord. I have the report.
There's no much of precipitation. When such person complies and continues to comply, no such.
Yes, kindly also look into, my lord, 35(5). Yes, thank you. My lord, this, my lord, situation would not have arisen, my lord, if he had complied with
No,
the
no,
fact-
by passing an order, I will ensure that ensure his appearance before the investigating officer and assistance to be provided for meaningful investigation. So therefore, this court's prima facie appears that custodial interrogation is not necessary considering the nature of allegation.
Kindly once also, sorry, my lord, kindly once look into 35(5) also, my lord.
Why 41A was dated?
Where such person complies and continues to comply with the notice, he shall not be arrested in respect of the offense referred to in the notice unless for reasons to be recorded, the police officer is of the opinion that he ought to be arrested. It has to be recorded. He has to comply with it, continue to comply with it, and my lord, then only, my lord, the situation arises. My lord, if he does not comply with it, my lord, 35(6) comes into play.
All this is overlooked by investigation.
That is why court is asking you that what are the reasons that he ought to be arrested
My lord, that
for the
is
sake of investigation.
first.
There is one influential point you have taken.
Yes.
Point
That is the point taken.
that the person is influential.
Absolutely. Absolutely. And my lord, he has to, my lord, the law is made to be complied with, my lord. He does not
And
comply.
another aspect is also traveling this court that this incident took place on 13th of December.
Yes.
The complaint was lodged when?
Later. Later.
When complaint was lodged, Mr. Mitra?
Much later, my lord, after, my lord, the change.
Yes, let me see the date of complaint.
30th of May.
30th of May.
Now, my lord, lordship is, my lord, possibly, my lord, looking into the
And
newspapers.
today you are afraid of that the petitioner is going to intimidate
Yes, for this simple reason.
intimidate the
For this simple,
witnesses.
for this simple reason, my lord, till, my lord, 30th of May, there was no.
Complaint was lodged after 6 months.
Yes.
Yes,
Yes.
because he is in custody.
So therefore, yes, you carry on your investigation. A petitioner will comply with notices and give assist the investigating agency in carrying out investigation, and petitioner will not leave the city without leave of this court, and he will not intimidate witnesses.
Now, my lord, only.
But at the same time, considering the nature of incident, which tarnish the image of this of the city, I will direct the appropriate police officer to conduct an independent inquiry as to why this has happened, this fiasco took place, and submit an independent report before this court.
But an SIT has been constituted by this court, which is on record. Page 66.
On
Kind-
such incident,
Yes, yes.
The appeal was made.
Yes. We're at page 62.
issue.
My lord, bear with me for 2 minutes, my lord, I am the complainant. My lord,
Subject.
I gathered the courage to lodge this
In
complaint already
cooperation
after
does not
3
happen from
months.
his side.
Because
Or
I
the
was,
petitioner. You have not said that.
I was told that fine, you have a family here. My lord, I was arrested, no issue with that, my lord. I am fighting my own case in the before the court of law. Now, my lord, kindly sees the gist of the allegations, whatever I have made. My lord, it's not that he has forcefully obtained tickets from me. He has obtained complimentary tickets from me, 22,000. My lord, the sitting capacity of the stadium is of more or less 70,000 plus. He has forcefully obtained 22,000 complimentary tickets. Then, my lord, and the proximity card also, whatever it may be. I had several meetings held with the then DGP and the highest police officials. I have informed them. I hand over the flowchart. The flowchart contains 3%. The then chief minister.
These are to be considered in the
My
course
lord,
of
may I
investigation.
just inform this honorable exactly what is the allegations, my lord, I am trying to.
Yes.
My lord, I have leveled against him. My lord, it's not that, my lord has put a question, my lord, as to why his custodial improvisation. My lord, may I just give a short answer to this?
Yes.
My lord, because he has taken 22,000 complimentary tickets from me, my lord, instead of distributing it to the fans and the other fan clubs and the other clubs of the city, he from a particular club which is known as Taliban Union Committee, which is a club situated within his constituent assembly, has black marketed those tickets to the extent of 30,000, and by this he has enriched himself with 66 years. My lord, not 100, 200. He has enriched himself.
You should have flagged the issue before the incident happened.
No, because my lord, kindly see, my lord, I have organized four events in all over India. Nowhere, everywhere it was.
Yes, that is court is also saying.
My lord, now.
But it has got a different ramification.
My lord, what has happened? Kindly, may I just inform this?
That is not the contents of your complaint.
That
Yes.
is,
That in order to satisfy the consents of the court, will direct the police
my lord,
authority to
that is
conduct
the
an
content
inquiry.
exactly
But
why
that is
we
not the
have-
contents of your complaint, Mr. Jana.
My lord, this, my point.
Let us come back to the complaint.
May I kindly?
Your complaint centered around complimentary tickets, accreditation card, and close proximity passes distribution.
Yes.
Yes,
My lord, may I just inform this honorable court? That is what I-
and the petitioner is alleged to have obtained wrongful gain,
My wrongful
monetary gain.
by a
That is
public
that is the crux of your
My
complaint.
lord, wrongful gain by a
The
public
the
servant.
fiasco which took place, which lowered which tarnished the image of this of the city, that is not the issue ventilated in your complaint.
My lord, all I have tried to inform.
Yes, sir.
My lord, may I, my lord, before you lord passes the order, my lord, whatever.
Yes, yes. Court is not finishing this matter today.
Yes.
Court is court is considering whether the interim order can be passed or not.
My lord,
So I have heard you.
my lord,
At this stage,
I have
further
not finished.
dilation is not required.
My-
Yes.
my- for a
But
second,
only
Matter is-
one line reply, my
Yes.
lord, to what my learned friend says.
my lord, for a second,
Mr. Mitro has made this.
Yes, for a second. Yes.
I'm sorry.
my lord, my lord, the offense committed by this person is that he has obtained those tickets, the complete ticket for distribution to the other clubs. But he has ultimately involved himself in black marketing of the ticket, my lord, and this has been committed by a public servant. Now, my lord, the investigation required exactly he
Oh.
and how many persons they are involved in
This
black
is the
marketing.
subject matter of investigation. This is the subject matter of investigation. This is court is not aborting investigation. Court will permit the investigation to be carried on expeditiously in accordance with law and ensuring presence of the petitioner before the investigating agency.
Yes.
May I take your lordship wants to the prayer? Kindly comes to page 34 of the prayer.
Yes, what does it say?
This is the first prayer. The prayer is issue a writ and a direction in the nature of mandamus, restraining the responsibility particular response 2 to 4 from taking any coercive action. He has not placed his PRS bill application to the district court. In the first place, my lord, he was given 35-day notice. He did not appear. That is what has been informed by the London Advocate General before the Honorable Court. Twice he did not appear. He took out a PRS bill application.
Mr. Jana, if I have two remedies and one, I have sought for one remedy and subsequently I decided not to approach that forum, but to approach the different remedy. What is the wrong in it?
No, then my lord, he has been, I will not allow this person. to
Yes,
go
yes,
into-
Mr.
My lord,
Dotto. I have
only
heard
thing is, my lord,
My lord, first is, my lord, what is creating problem, my lord, there is a judgment of this court that even after rejection of anticipatory bail, one can come up for quashing. But these are all on different parameters. Be that as it may, my lord, the de facto complainant stand over here is completely, my lord, different to.
But at the same time, Mr. Dotto, there is an observation by the Supreme Court by by Dr. Justice Chandrachud in Niharika Infrastructure that
Yes.
at the preliminary stage it ought not to be interfered with. Rather, the accused person has a remedy to apply for pre-arrest bail.
My lord,
And
here
yes,
is-
No, definitely. Definitely. There is no bar. There is no bar. But the stand today is contrary to what is there in the records of this court. Kindly come to page 62. Before the division bench, what is the stand of the de facto complainant? Before the division bench, kindly have a look to Millard. There is a long order. Millard, apropos Millard, what my learned friend submits.
That's fair.
yes. Matter is taken up. Matter is heard in presence of the learned advocate representing the petitioner, state respondents, and respondent number 5 being the de facto complainant. Stop. Stop. Mr. Kishore, next paragraph. Mr. Kishore Dotto, learned senior advocate representing the petitioner, has approached this court with the present writ petition, inter alia, praying for quashing of criminal prosecution being Vidhannagar South PS case number 138/2026 dated 30th May 2026, which was 30th May 2026 under section 308 within bracket 2/3018 within bracket 4, 351 within bracket 2, 61 within bracket 2, 3 within bracket 5 BNS. Hey, would it ইমিডিয়েটলি ডাকুন, তো খেয়ালই করিনি মামলা শুনতে শুনতে। ইয়েকে শুভেন্দুকে ডাকুন। অর্পণকে ডাকুন। Next paragraph. Concerned police authority initiated a criminal prosecution being Vidhannagar South PS case, South Police Station case number 138/2026 dated 30th May 2026, based on complaint of respondent number 5. Based on complaint of respondent number 5, based on complaint of respondent number 5, alleging
করে দেন, এর মধ্যে ঢুকিয়ে দেন। এই বছরের নিচে
for the sporting event slated to be organized on 13 December 2025, where Lionel Messi, within bracket popularly known as Messi, a soccer legend, was scheduled to be present at the field of Jubo Bharati Kirangon it is alleged in the complaint that complimentary tickets, accreditation cards, and close proximity passes petitioner was compelled to hand over to the respondent number 5 was compelled to hand over to the petitioner, being the then sports minister, and those complimentary tickets, accreditation cards, and close proximity passes were wrongfully distributed for financial gain. Stop. In connection with, next paragraph, in connection with aforesaid criminal prosecution, notice under section 35(3) of Bharatiya Nagorik Suraksha Samhita 2023, within bracket BNSS 2023, was issued on 1st June 2026 to the petitioner, which petitioner did not comply with, and subsequently present writ petition is filed praying for quashing of criminal prosecution.
Well, there was a subsequent notice. I'm sorry, there was a subsequent notice also.
Stop.
Two notices.
It is submitted by Mr. Mitro, learned Advocate General, Mr. Surojit Nath Mitro, learned Advocate General, that representing the state respondents, that another notice under section 35 within bracket 3 was issued. Subsequently, the notice dated 1st June 2026, which was also not complied with by the petitioner. Stop. Next paragraph. It is contended on behalf of the petitioner that without any preliminary investigation, aforesaid criminal prosecution commenced. Stop. Another limb of submission made on behalf of the petitioner is section 35 within bracket 3 of BNSS 2023, which grants protection to the petitioner from being incarcerated during continuance of investigation if notice under section 35 within bracket 3 is complied with. Stop. At this stage, prayer is made on behalf of the petitioner to grant protection subject to final result of the present writ petition. Next paragraph. Mr. Mitro, learned Advocate General, Mr. Mitro, learned Advocate General, has opposed this writ petition, and it is brought to the notice of this court in reference to the statements made in paragraph 26 of the writ petition. That an anticipatory bail application was taken out before the learned Sessions Court, Barashat, North 24 Parganas, by the petitioner, and petitioner ought to have pressed that pre-arrest bail application before the Sessions Court. Stop. In addition thereto, it is also contended that petitioner was sports minister at the material point of time when the incident took place on 13th December 2025. Therefore, being an influential person, petitioner may impact, or being an influential person, petitioner may intimidate witnesses, affecting process of investigation or affecting investigation. Stop. According to the state respondents, since two previous notices under section 35(3) of BNSS were not complied with by the petitioner, he is not entitled to get the protection as envisaged under section 35 within bracket 3. Stop. Next paragraph. Mr. Orindam Jana, learned advocate, represented respondent number 5 being de facto complainant, who has also opposed this writ petition, and it is submitted that considering the nature of allegation made against the petitioner, petitioner is not entitled to get interim protection during pendency of the writ petition. So, according to respondent number 5, for the sake of investigation, if investigating agency finds it apt, it may take the petitioner into custody. Next paragraph. Having considered the respective submissions made on behalf of the parties and taking note of the contents of the complaint dated 30th May 2026, it appears prima facie it appears that grievance of the respondent number 5 centered around distribution of complimentary tickets, accreditation card and close proximity passes. By the petitioner, leading to unlawful financial gain, stop. Based on such complaint, criminal prosecution was initiated under section 308 within bracket 2 . Now, a criminal prosecution was initiated under certain provisions of BNS or Bharatiya Nyaya Samhita 2023, out of which two provisions out of which provisions contained under section 308 within bracket 2 and section 3018 within bracket 4 কি বললাম out of which offense provided under section 308 within bracket 2 and 3018 within bracket 4 offenses called are albeit cognizable and non-bailable, but prescribed punishment in both the cases, but prescribed punishment under both the sections are up to 7 years. Stop. Hence, court finds at the stage of investigation, if petitioner cooperates with the investigating agency and complies with the notices issued in connection therewith, he can get protection, or he is entitled to get protection under section 35 within bracket 3 of BNSS 2023. Stop. It was argued on behalf of state respondents that benefit contemplated under section 35 within bracket 3 may not be attracted herein, since petitioner failed to comply with two previous notices under section 35 within bracket 3. Stop. At this stage, court is not ad idem with the submission made on behalf of the state respondents concerning extending benefit under section 35 within bracket 3 of BNSS 2023 due to failure of complying notice under complying previous two notices. In the event it is ensured presence of the petitioner before the investigating agency for the sake of investigation in compliance of future notices issued by the concerned authority. Next paragraph. It is true that petitioner preferred pre-arrest bail application before the Sessions Court, but mere filing of pre-arrest bail application does not impinge upon right of the petitioner to invoke jurisdiction of this court under Article 226 of the Constitution of India, questioning initiation of aforesaid criminal prosecution. However, these observations are made based on prima facie considerations. Next paragraph. In view of aforesaid conspectus, investigating agency is permitted to continue with the investigations in accordance with law. Stop. Petitioner shall comply with notices to be issued by the investigating agency and shall appear before the investigating agency on the fixed date and time, failing which state respondents shall be at liberty to bring it to the notice of this court for passing appropriate order. Stop. At least 48 hours notice shall be issued to the petitioner, permitting him to appear before the investigating agency. Stop. Petitioner shall not leave station without the permission of this court. Next paragraph. Lionel Andres Messi, popularly known as Messi, is a soccer legend who was slated to appear at the field of Juba Bharati Kirangan on 13 December 2025 in front of large number of spectators. Stop. However, on the date when this program was scheduled, Messi had to leave the field much prior to scheduled time due to security breach. And it was seen on news media that large number of intruders were present at the field on 13 December 2025, when the program was organized. Stop. Thousands of Messi fans purchased tickets to witness presence of their hero at the field, but early exit of Messi from the field shattered their dreams. Stop. At the same time, it was found. Na, at the same time, aage karo. It was a complete fiasco in organizing such event at Juba Bharanti Kirangan, Kolkata. Stop. However, in 3 other metro cities, Hyderabad, Mumbai, and in Delhi, similar program was organized seamlessly. Stop. Failure to organize the program left a blot on the image of this city, within bracket Kolkata. Stop. While granting, next paragraph, while granting interim protection to the petitioner, this court cannot shut its eyes to such messy event fiasco. Stop. Conscience of this court leads to pass a direction upon the who would be the appropriate authority to conduct an independent inquiry. Mr. Mitro.
Lord, since we are an SIT, Lord, may I make this submission? Since an SIT has already been constituted.
Yes, no, I will pass in a separate order. Yes.
Very.
So it's
Supervision.
Yes, Mr. Mondol.
or CP Vidhan.
Whether he is party, Commissioner of Police, Bidhannagar, Police Commissionerate. Mr. Dotto, he is not a party.
So he's not a party.
No, your lordship,
I'll grant you leave to make him party.
lordship can give direction, my lord.
Yes, that's fine, because he need not be a party. It's an independent body. Your lordship can always be Lord.
Commissioner of Police, Bidhannagar Police Commissionerate is directed to conduct an independent inquiry as to why
Village police holo.
the event could not be organized appropriately on 13 December 2025 and submit a report by 4 weeks from date. Stop. Next paragraph. The interim protection granted to the petitioner. देखिए ওই রেলিভেন্ট জায়গাটায় বলো তো কি ডিরেকশন দিলাম না তার আগে ওই যে he will appear before the investigating agency and other thing. হ্যাঁ Stop. No, ওখানে একটা অ্যাড করে দাও, no coercive step shall be taken against the petitioner without the leave of this court till ওইখানেই দেবে till 17th August 2023 or until further order whichever is early. এইবার ওখানে শেষে কি বলছিলাম দেখো, ওটা ওইখানে কিন্তু ঢুকবে, হ্যাঁ ছেড়ে গেছিলেন, হ্যাঁ শেষে লাস্টে হুম। না এখানে আসলে বলা দরকার নেই, সেন্টেন্সটা পুরো বলো। No, are into protection. Next paragraph. List the matter under the same heading for further consideration on 17th August বললাম তো, 4th August 2020.